Hello friends, this is Bikramaditya Ghosh. Today's video is one of our monthly initiatives, that is current affairs module, which is specifically designed for the purpose of law optional, for preparation of our law optional paper. Now in my other videos regarding strategy, if you could remember or recall, or if you have gone through that video, I have specifically mentioned that connecting the current affairs with law optional is one of the key strategies in taking your score in the 280 range or even above. And apart from that, these days if you see the paper, you will find that there is a trend where even the UPSC paper setters, they ask questions from current affairs. They will relate one question, current affairs topic, with one of the particular items in your syllabus, and that way, preparation of current affairs or connecting your preparation with current affairs has become very important these days. And apart from the fact that this also enhances our capacity to do better, particularly in GS2. Now, so far as law is concerned, if we look at the news which keep coming in the newspaper, in the other websites or whatever sources you refer to, we will see that particularly concerns constitutional law and to some extent international law and international relations. So apart from that, whatever we will be getting from time to time, every month, what happens, a new act or a new bill comes in, if it has any connection with our law optional syllabus, of course we will also look into that. Now this initiative on the part of the upsclawoptional.in is to give you a snapshot as to what has happened in the present month, and to enable you to connect it with your law optional syllabus. So every month we will be coming up with one such initiative wherein we will cover the entire topics of current affairs which is relevant for that particular month. And this initiative you can find in our website. We are producing this module in the name of Bridge, which is a current affairs module that connects law optional and the current affairs. So that's why the name Bridge. So you can have a sample copy of one of our modules in our website. Now this discussion what we will be having today, so far as this video is concerned, this is for the month of January 2020. We have collated the news and articles that could have been relevant for us pertaining to the entire month, and we will have a look at those issues which we feel can be relevant for your law optional syllabus. Now our endeavor was to make it in such a manner which will be helpful for you to understand the topic, to remember and get the main points which are there in the topic, and also to ensure that you can connect it with your law syllabus in a more convenient manner. So that's why we thought that we should produce this module in the form of mind maps, which is of course it's somewhat kind of interesting. It doesn't seem very monotonous. If you go through a mind map, it's also easy to understand, and many other things. That's why we thought to do it in this way. So that's what it is. So today the first topic is, which we are hearing a lot in the news channels or the newspapers. It's about proposal for the All India Judicial Service. Now this was in the pipeline since a long time. It was first introduced by the 14th report of the Law Commission in 1958. The first National Judicial Pay Commission, that is Justice Jagannath Shetty Commission, in 1996 has also recommended establishment of this All India Judicial Service for the purpose of filling the vacancies of district judges. Subsequently, the Saran Singh Committee's recommendation, that is 1976, here also the All India Judicial Service was recommended. Now how this topic or this discussion which we see in the news is relevant for us? This is relevant for two things. One is the cooperative federal concept which our constitution cherishes. So far as center-state relation, this topic becomes important. So far as cooperative federalism is concerned, as of now in the present system, recruitment of judges, particularly the district judges, is more a state-oriented thing. The state government recruits through various modes, though the judges are thereafter placed under the administrative control and supervision of the High Court. Now, those judges who are recruited through the state's public service commissions, they subsequently get promoted to the level of district judge after a particular point of time. Now, apart from that, there is also a limited competitive exam through which the normal judges who are in the other cadres, they are considered for promotion to the cadre of district judge. And now subsequent to the Malik Mazhar Sultan's case, which is now pending before the Supreme Court, we also have the direct recruitment system, so which is from the members of the bar, and this examination is conducted by the state high courts. Now, these are the modes of recruitment. So basically, it's apart from the direct recruitment mode which is there, the other two modes are basically state oriented, because the initial appointment of the judges has been done by the state government itself through the public service commissions. So that's how it is. Now, if All India Judicial Service comes into place, it certainly will have an impact on the center-state relations and also cooperative federalism that we know is one of the core aspects of our constitutional structure. From that angle, we will evaluate this. Now, what are the advantages even if we have this in place? What are the advantages? Now, first is an unified judiciary. So this is one of the advantages. So one common cadre, one common system we will serve throughout the country, akin to the All India services like Indian Administrative Services or the Indian Police Services. The second is, yes, if it is a All India service, maybe remunerations will be higher, it carries other comparative benefits, so it is expected that the best talents will be attracted to come forward and write the exams and take up the job under these services. It is said that it addresses the lacuna of state mechanism regarding vacancy and merit. So in many states we have seen now judicial vacancy is also one of the topic which is very oft discussed in our newspapers, and also this is also something which will address that question of vacancy, or it is likely to address. Speedy recruitment and filling up of vacancies, these two are kind of connected. So you can have a look at those advantages here. Now, there are also certain concerns, like what are the negatives? The negatives are independence of judiciary. Presently, the system of direct control of high courts, as I have earlier said, is there in place, which controls the posting, transfer and appointment of district judges. That might get a little interfered to some extent. Now, another is the centralization and the federalism debate, which I have mentioned earlier. Now, it is already in the news, very often it is discussed that things are being centralized. The central government is trying to usurp the power of the states or the union territories, sometimes vice versa. This has a bearing on Article 233. So far as appointment of district judges are concerned, you can have a look at Article 233 once. And another aspect is that if it is a All India Judicial Service, the important question of reservation shall always be there, because so far as states are concerned, the communities which are economically and socially disadvantaged in the states, they are given reservations. But once All India Judicial Service comes in, that scheme of reservation might not be there. The local communities who are economically and socially backward, they might not reap as much advantage as they could have been otherwise. The last one is a practical difficulty, that's regarding local language and local laws. Now, a candidate from Gujarat or Maharashtra, if he comes and recruited as a district judge in Assam or West Bengal, of course he will have problem understanding the local language and the local laws. So these are the comparative disadvantages that we have. But in any event, since this is in consideration since long, today or tomorrow it might come up, it might get implemented through an act or an amendment of the constitution, whatever it may be. So we have to understand this in our own perspective. Now we have to connect this with the concept of cooperative federalism. Now any question comes regarding cooperative federalism, we can make an effort to connect this topic with the concept of cooperative federalism. Now coming to the next topic, this is regarding restrictions on internet in Kashmir. Now there was a proceeding which was carried to the Supreme Court. The question was how to sort out this conflict. On one hand we have Article 19, that is freedom of speech and expression. On one hand we have the restrictions which were imposed in the manner of imposing orders under 144 CRPC. Now 144 CRPC is also a topic under IPC, so this topic has relevance for at least two modules. One is the fundamental rights, that is Article 19, actions of IPC, that is the offences against public tranquility. So from these two angles we will discuss or have a look at this topic. Now the context is that since the revocation of Article 370 on 5th August 2019, Jammu Kashmir, or a substantial part of Jammu Kashmir, has been placed under lockdown with no internet and restrictions of movement. Now what the Supreme Court observed? The Supreme Court said that freedom of speech and expression through the medium of internet is a fundamental right under Article 19(1)(a) of the Constitution. Now while studying 19(1)(a), we have seen newspapers, we have seen other medias. Now this is the time while we are considering internet as a medium to express our freedom of speech and expression. So that's how we are looking at internet in a new way. So Supreme Court says it's a fundamental right. Now if we want to have restrictions, if you could recall the reasonable restriction clause under Article 19, it says the state may impose any kind of restriction which is otherwise reasonable. There are many case laws which we have discussed under that topic, or we will be discussing under that topic. So here we have the restriction and the exercise of rights, the act of balancing, that becomes important. So the Supreme Court said it has to be evaluated under the principles of proportionality. Proportionality means the restriction should be proportional as to what the government wants to achieve and as to what can be a disproportionate imposition of powers by the state government. So the court says that states' interference with the exercise of a right must be proportionate to the goal it seeks to achieve. Freedom of trade and commerce through internet is also a constitutionally protected right under Article 19(1)(g). Now you see, it's another aspect of speech and expression which the court brings in here. It's the court expands the view and says that apart from speech and expression, even trade and commerce, which is also something which is protected under Article 19(1)(g), internet has a very close connection with trade and commerce these days, which is absolutely true. Every day we order something from Amazon, from Flipkart, we get it delivered to our home. So if you don't have internet, certainly trade and commerce today, as on today, it gets affected. So the court held that suspension of internet for indefinite period is not permissible. Well, you can have a riot-like situation for 3 days, 4 days, a week or a month. Then subsequently you have to take a lenient view. You have to respect the liberty of a person. You have to respect the rights, valuable rights which are granted under Article 19, and accordingly you have to balance the restrictions. So it can be a restriction can go on, but it has to be proportionate. You have to give some kind of concessions, you have to give some kind of limited access to internet, however way the government wants to do it. So it's basically the principle of proportionality which has to be looked at. Now in this context, we also have to understand what are the legislative provisions. Now, so far as Jammu Kashmir is concerned, as far as my limited knowledge goes, we will find that it's more under Section 144 where the restrictions are being imposed. But under the Telegraph Act, there is also one more rules which has been framed by the government, which says that the government can impose restrictions under the Telegraph Act also. So this is temporary suspension of telecom services, public emergency or public service rules. This is here we have mentioned it under the Telegraph Act. This also governs suspension of internet. However, despite having the 2017 rules, the government has often used the broad powers under section 144 CRPC. Why is it so? Because it's all, of course, the government will say it's because of administrative exigency that the government thought it fit to use 144 more rather than invoking this specific statute. So we will try to understand this topic from the perspective of Article 19, because whenever a question is asked from Article 19, you will see it's very common that questions are being asked from Article 19 almost every year. Freedom of speech and expression, restrictions, trade and commerce, everything. So whenever we see Article 19, 19(1)(a), we will try and connect it with this internet aspect also. So this gives a good impression to the examiner that yes, this person or this candidate appraised of the current affairs and he has referred to something which is relevant. Now the next topic is the Supreme Court's proposal to the Parliament to amend the Constitution so that the power of the Speaker to exclusively determine on the issue of defection can be taken away and placed under the jurisdiction of a tribunal. Now, as you know, there is anti-defection law which forms one of the schedules to our constitution. This was basically brought in place to curb, or you say some unfair practices in the political domain, so that a person who gets elected from one political party, he or she does not switch parties thereafter for their own political benefit. This was in short the concept of the anti-defection law. Now once the law came into place, it was also ensured by the legislature that the power to decide as to whether an event of defection has taken place or not, that power was vested on the speaker of a legislative assembly so far as states are concerned. Now from the amendment itself which brought in the anti-defection law, it was very clear that it was the intention of the legislature that this power should vest with the speaker himself and no one else. So you see the legislative intent is quite clear. Now why Supreme Court has considered this? We have to understand the context. We have a very recent incident from Manipur where disqualification of a Congress legislator who joined BJP after the 2017 assembly elections. The Congress had asked the Manipur speaker to disqualify him and the speaker failed to act and kept the petition pending. This was one of the recent incidents, while we have seen obstinacy of the speaker to exercise his powers so far as defection is concerned. Similarly, in Karnataka also few years back we have seen similar incidents where somewhat the speaker acts in his own whims and fancies, or sometimes political exigencies or political reasons come into play which influences the otherwise impartial or independent position of the speaker or his independent decision making faculty. So in Telangana also there are incidents. In 2016 this has happened in Telangana also, where the question of the speaker was under scanner. Now the Supreme Court has observed that Parliament to substitute the Speaker of the Lok Sabha and Legislative Assemblies as arbiter of disputes concerning disqualification under the 10th schedule with a permanent tribunal. So the Supreme Court says, well, enough is enough. You consider whether this power can go away from the speaker and whether it can be vested on a tribunal. Now how this tribunal should look like? It should comprise of a judge of the Supreme Court or the High Court. That's how it should look like, the tribunal. So now the question is how we will consider this topic, this entire discussion in our law optional syllabus. Now this has a relevant significance so far as separation of power doctrine is concerned. Now as I have said, you see the legislative intention is that the power should be with the speaker, which is a part of the legislature. Now once this goes in the hands of a tribunal, the retired high court or Supreme Court judges being members of the tribunal, there will be a overlapping of exercise of powers so far as the question of defection is concerned. So we have to consider this from the aspect of separation of power doctrine. How when legislature intends that some power should vest exclusively with one branch of governance, be it judiciary, be it executive, be it legislature, can the Supreme Court come in and say that no, this should not exclusively vest with the legislature, with the executive, or with the judiciary? Someone else should also take care of this. Now this debate was also relevant when we have seen the question of appointment of judges a few years back. When the Judicial Appointments Commission bill came into place, there was a lot of debate as to who should be the dominant player, whether it should be the judiciary or whether it should be the executive so far as appointment of judges are concerned. Now this is also one angle, a new aspect so far as separation of power is concerned. So any question if asked regarding this topic, one must remember that don't forget to write at least one line in the conclusion or somewhere else in your answer, and try and connect this topic. Now so far as Administrative Reforms Commission's report is concerned regarding ethics in governance, we have seen that the ARC had earlier already recommended that the question of defection should be decided by the president or by the governor on the advice of the Election Commission. So I don't know whether Supreme Court how far has considered this recommendation. This also appears to be a fairly good idea as to balance the possibilities of arbitrary action or inaction on the part of the speaker and the democratic principles. Now the Supreme Court has further said that generally it should be decided within 3 months. You cannot keep it pending indefinitely at your own sweet will. Apart from this, the Supreme Court has also mentioned the parliamentary practices which are there in Britain, where by convention political parties do not field a candidate against the speaker at the time of general elections, and the speaker can continue in office until deciding otherwise. By convention, the speaker also gives up the membership of his or her political party. So this implies that in UK jurisdiction the speaker acts more as a neutral person. Now here also in Indian system also in a fairly good manner you will see that upon election as a speaker or of the legislative assembly of the or the parliament, the speaker is expected to play a more neutral role. So however in India unfortunately or fortunately the speaker always does not present a very politically neutral stance or a politically neutral position, which is not the position in the United Kingdom. Now of glaring exceptions, if you get some leisure time, you can go through this book. It's called Keeping the Faith. It's by our former speaker Somnath Chatterjee, who was apparently a very independent and fierce person so far as parliamentary democracy is concerned. So if you read the book, you will understand many things about how a speaker is expected to be neutral and how Indian democracy has responded to that. Now I will suggest you, if you get time, kindly go through this book sometime. Now we'll coming to the next topic, that is this is more related to the international law part, particularly the International Humanitarian Law module and also the power and jurisdiction of the ICJ. So this is a proceeding regarding the Rohingyas. The Rohingya issue is now very one of the most talked about topic so far as general studies is concerned. Now Rohingyas, they're persecuted communities in the world. That's what the entire world, the United Nations has also endorsed such views. National and international governments have endorsed that view. The background was that Myanmar and Gambia, both those countries were parties to the Genocide Convention. Now, Genocide Convention is one of the conventions. We have important aspects of Genocide Convention. It has been ratified and acceded by 152 states, including India. The convention defines genocide, and the convention also lays down what can happen or what cannot happen in a scenario where a government, a nation state feels that an event of genocide is taking place in a particular country. Now, Gambia moved before the International Court of Justice, saying that Myanmar, the acts and inactions or actions of Myanmar so far as Rohingyas are concerned, amounts to genocide. Now, Gambia moved before the court in November 2019 against Myanmar, alleging violations of the Convention on the Prevention and Punishment of the Crime of Genocide. Now, Gambia basically said that Myanmar is violating the convention, therefore ICJ should interfere. Now, ICJ considered the matter, and what we are considering today is an interim order, as we call in Indian law. It's an interim order. It's not a final order. It's an interim order, which, you know, in terms of ICJ statute, what we call is provisional measures. So if you study powers, functions and jurisdiction of the International Court of Justice under the module organs of the United Nations, you will see that ICJ has a power to pass such orders, thereby providing provisional measures. Now, provisional measures are akin to interim orders as we understand in Indian law. So, what ICJ has said, number one is that it has the right and preliminary jurisdiction to hear a case seeking emergency measures to prevent Myanmar from committing genocide against its Rohingya community. So, you see that this is a preliminary jurisdiction which the ICJ is exercising to grant provisional measures. It has also further ordered Myanmar to take all measures in its power to prevent genocide against the Rohingya. So, you see the ICJ is actively interfering so far as the issue is concerned. Now, thirdly, the court says the court has asked Myanmar to submit a report to the ICJ on all measures taken to give effect to the order within 4 months, and thereafter every 6 months until a final decision is passed. So, basically ICJ has indirectly ensured that Myanmar follows the provisions of the Genocide Convention. Myanmar abides by the provisions which are there in the convention, the way the convention wants a country to act in the event it appears that the country is committing genocide towards a particular community or a race. So that's the entire topic is all. Let's connect this with the law optional syllabus. What we are supposed to do? Any question touching upon the module of international humanitarian law, we will try and connect and, you know, write a few lines about this case, or thinking it in a different manner. While discussing the provisional measures or jurisdiction of the ICJ, if we get a question from this module, we can also, you know, write this, that recently ICJ in the matter of Gambia and Myanmar has intervened and passed provisional measures. Which are the provisional measures? These are the provisional measures which we have already discussed. So that way we have to connect the topics which we have in our syllabus with the content that we get from current affairs. Now, moving to the next topic, it's one of the most common or oft talked about topic, that is the issues regarding South China Sea. Now, this pertains to the law syllabus so far as international law is concerned. This touches upon the topic of law of sea. You have seen the UN clause, United Convention on the Law of Seas. Secondly, we have already read maybe in the last year or few months ago, or some of you who are going through the current affairs module, you will see that there has already been an arbitral tribunal which has decided on this issue. The arbitral tribunal has passed an order where the aggressive acts of China has been criticized. Now, the arbitral tribunal has also said that those acts of aggression are not justified under the international law of sea. So, we will also consider this topic from the angle of peaceful settlement of disputes, which is there in the international law syllabus. Now, we can also think of it in a different manner. arbitration is one of the peaceful settlements of dispute. There is no doubt about it. In our international law materials we have seen arbitration is one of the mode of peaceful settlement of disputes. Now how far arbitration is successful as a peaceful settlement of dispute, we can bring in this topic of South China Sea. This will give a very good impression, because you see that in spite of the fact that the arbitral tribunal has passed an order, there is no implementation of the orders. The Chinese government is repeatedly violating the order as if nothing has happened. The arbitral tribunal is helpless. They don't know how to implement the order. The countries surrounding the South China Sea is also in a mess. So this raises a question as to efficacy of arbitration as a peaceful settlement of disputes. So we will consider this topic from that angle also. The context we already know, the consistent and aggressive activities of China, including the recent move of China to deploy an airship in the South China Sea. Now conflicting claims of adjacent states, this is where the legal problem begins. The territorial conflict is there so far as Philippines, Vietnam, Brunei, Taiwan, Malaysia, those states are concerned. Sometimes those countries are making overlapping claims over the over their jurisdiction so far as South China Sea is concerned. There are also concerns regarding as to the areas of fisheries zone that are there within the South China Sea. If you connect this with the United Convention of Law of Seas, you will understand that there is a different concept called fisheries zone. Now all those countries, they must be having overlapping claims over South China Sea. So we have to look it from that angle also. Now China has claimed that more than 80% of the area which comprises of the South China Sea belongs to them. There is something called 9-dash line, which I believe you must have read regarding GS2 in international relations. So these claims or aggressive acts on the part of China has in fact raises question whether their acts are in consonance with the United Convention of Law of Seas, particularly regarding the topics of jurisdiction. What can be the jurisdiction of a state so far as the sea is concerned? How far the territorial jurisdiction of a state can extend in a sea? So we have to evaluate this in the parameters of what we study under the topic of law of sea. UN clause arbitral tribunal, which has already came up with a decision, it says that China cannot claim historic rights to resources in the waters within the 9-dash line encompassing much of the South China Sea if these waters are within the exclusive economic zone of other coastal states. So you see, EEZ, the exclusive economic zone, is also one of the concepts on which you can get some clarity from the UN clause. So while studying UN clause, we will discuss this topic further, but for the time being you have to keep in mind that this is what has happened so far as international relations are concerned. This is what has happened in South China Sea, and whenever there is a question asked from law of sea touching upon the questions of exclusive economic zone, fisheries zone, or even territorial jurisdiction of coastal states, we have to somehow connect it with the topic of South China Sea. That's one way of writing a better answer. Now here we have provided that what are the legal issues, the rights and states, the rights of nation states in exclusive economic zone under UN clause, fisheries zone and its recognition, a remedy in case of infringement, whether the acts of China amounts to aggression under international law. That is also one angle from which we will look at it. And lastly, how efficacious is arbitration as a method of peaceful settlement of disputes, as I have discussed earlier. So now moving on to the next topic. Now this is one more interesting topic which has also a substantial bearing on India's federal structure. The proceedings which Chhattisgarh and Kerala has brought before the Supreme Court, challenging some of the acts and legal provisions. Now Kerala has moved before the Supreme Court challenging the Citizenship Amendment Act, which was much in debate of late regarding its provisions for protection of religious persecuted communities from the neighboring states and all. So Kerala has challenged the provisions of the Citizenship Amendment Act, stating that it is violative of Article 14 and violative of Article 25 and 25 also. It also challenges the Passport Entry to India Amendment Rules and Foreigners Amendment Order, which had regularized the stay of non-Muslim migrants from Pakistan, Bangladesh and Afghanistan who had entered India before 31st of December 2014. So, you know, all those amendments so far as the Passport Entry of India rules are concerned or the Foreigners Amendment Order is concerned, this is basically connected with the Citizenship Act. So, in order to give effect to that particular provision for protection of religious minorities of the neighboring states, those consequential amendments had to be passed. Now, Kerala has challenged all of those together. Whereas Chhattisgarh has went before the Supreme Court on a different issue. They have challenged the the NIA Act which governs one part of the police functions of the state. Now Chhattisgarh says that police is a state subject. Now if you make an amendment to the NIA Act, of course it has a bearing with the police powers of the state. So if you bring an amendment to that act, so it obviously will have a bearing on the jurisdiction of the state, and such amendment, after having obtained the consent or the concurrence of the state government. Now that was not done. So the Chhattisgarh moved before the Supreme Court challenging this amendment. Now here we will discuss this topic on from several angles. Number one is the center-state relation. So how the center can bring in amendments or acts or legislate on things which infringes the center-state division that we have under Schedule 7 of the Constitution, that is legislative powers of the state. Legislative power of the center and the state. Now this is one angle from which we will discuss it. The another angle that can be that powers and jurisdiction of the Supreme Court. Now when the Constitution was framed, the framers of the Constitution envisaged that there will be times when center-state conflicts might happen. Now who would resolve the disputes if such things happen? One state going against another, one state going against the center, one union territory going against another state, some legal disputes come up. We have seen interstate river water disputes which has now been vested with a particular tribunal under a particular act, that is Interstate River Water Disputes Act, or there is a tribunal which now adjudicates. Now so far as state versus state versus center disputes are concerned, there has to be a mechanism. So the Constitution makers, they have brought in a provision under Article 131 of the Constitution, which is the original jurisdiction of the Supreme Court. Now original jurisdiction of the Supreme Court, particularly it refers to disputes between center and the state, state versus state. Those are the kinds of dispute which the Supreme Court requires to adjudicate under Article 131. Now center-state dispute resolution is something which was somewhat taken care of under Article 131. But the question is why this special mechanism was required. The answer is obvious, because states cannot prefer a writ petition under Article 32 or 226 as INU can do before the Supreme Court. The state cannot do so, so there has to be a special mechanism. So this is the special mechanism in the form of original jurisdiction. Now original jurisdiction excludes the following: something which does not fall within the original jurisdiction. What are the things? This is a list of that. A dispute arising out of any trade agreement, covenant, engagement or other similar instruments. Such agreements or covenants which has been executed before the commencement of the Constitution and provides that the jurisdiction of the Supreme Court shall not extend to such a dispute. So if there is a agreement or covenant or any kind of engagement which conforms to this three parameters, it is excluded from the original jurisdiction. Secondly, disputes relating to use, distribution or control of the water or other interstate rivers. So here we have already said that there is now a special act for this, there is a special tribunal for this, which will discuss and adjudicate regarding interstate water disputes. Now, suits brought by private individuals against the government of India or state, that is of course not included within the original jurisdiction. So this is how we will consider and this topic from two angles. One is the center state relation, the other is the jurisdiction of the Supreme Court. Now having said that, for the month of January 2020, we felt that those are the most important topics which has a substantial bearing with the law optional syllabus. So these are the topics we have discussed it. Hope you have understood how the current affairs should be approached being a student of law optional, and how to understand or connect the law optional syllabus with the current affairs. You can have a look at those topics. You can have a look at our monthly module that is called Bridge in our website, that is UPSC Law Optional.in. You will see those modules there, and of course you can have our video lectures on monthly current affairs, which will be updated from time to time in our website as well as in our YouTube channel. Thank you for your time.